Government instituted slavery using franchises. Okay. Here's effect of accepting franchises upon your civil status. Or you got the sovereign status, and then you got the status in Fed law after accepting the franchise, which is the all caps letter name or your straw man. So, human being born within and domiciled within a state of the union is a non-resident non-person as a sovereign, private man or woman, constitutional but not statutory citizen. Also see why you are a national, state national, and constitutional, but not a statutory citizen. A stateless person, transient foreigner, and a foreigner. So on the status in Fed law, after accepting franchise, which is your all caps letter name, you become a resident alien, a non-resident alien, a non-resident alien individual. Public officer, a trustee of the public trust, statutory U.S. citizen pursuant to 8 U.S. Code 1401, because representing a federal corporation under 28 U.S. Code 300215A, which is a citizen pursuant to Fed Rules of Civil Procedure 17B, not a constitutional citizen of the United States pursuant to 14th Amendment. Inhabitant, a domestic person, U.S. person, 26 U.S. Code 7701830. Domiciliary, a statutory estate as defined in 4 U.S. Code 110D. C. Federal Trade Zone Act 1934, 19 U.S. Code. Domestic person, U.S. person, 26 U.S. Code 7701 830. Statutory trust. A domestic person, U.S. person. A domestic person, U.S. person, 26 U.S. Code 7701A 30. Persons already privileged. Warning. Participating in any government franchise can leave you entirely without standing or remedy in a Fed court. Essentially, by eating out of this government's hand, you are screwed, blacked and blued, and tattooed. The language below comes from a Brady's Rules for the U.S. Supreme Court. These general rules are well settled that the United States, when it creates rights in individual against itself, a public right, which is a euphemism for a franchise to help the court disguise the nature of the transaction, is under no obligation to provide a remedy through the courts. United States XL. Oh, dang, that's fucked up. That where a statute creates a right and provides a special remedy, that remedy is exclusive. Okay, that's all the cases. Still, the fact that the right and the remedy are thus intertwined might not, if the provision stood alone, requires U.S. to hold the special tribunal involved, no disputed question, excluded the right review by the Court of Claims. With the decision of the special tribunal involved, no disputed question of the fact that the denial of the compensation was rested wholly upon the construction of the act. So you don't get no remedy for participating. For the detailed exposition of why the above is true, see also Allen versus Graham. Signing up for government entitlement hands them essentially a blank check because they, and not you, determine the cost of the service and how much you will pay for it beyond that point. This makes the public servant into your master. Why government instituted slavery using franchises, your all caps letter name. And beyond that point, you must lick the hands that feed you. Watch out, never ever take a handout from the government of any kind, or you will end up being their cheap whore. The Bible says this: whore, Babylon the great harlot. Remember, Black's Law's Dictionary defines commerce, e.g., commerce with the government, as intercourse. Yeah, bend over. That's great. Commerce, intercourse by way of trade and traffic between different peoples or states and the citizens or inhabitants thereof, including not only but the purchase, sale, and exchange of commodities, but also the instrumentalities, governments, and agencies by which it is promoted, and the means and appliances by which it is carried on. Black's Law's Dictionary, 6th edition. Government franchises, which is your all caps name, and licenses are the main method for destroying the sovereignty of the people. Pursuant to 28 U.S. Code 1603b3 and 28 U.S. Code 1605a2. They are also the main method that our public servants abuse to escape the straitjacket chains of the Constitution. Below is an admission by the U.S. Supreme Court of this fact in relation to Social Security. We must conclude that a person covered by the Act has not such a right in benefit payments. This is not a say, however, that Congress may exercise its power to modify the statutory scheme free of all constitutional restraints. For further details on how franchises destroy rights and undermines the constitutional requirement for equal protection, read your constitution shit. Legal definition. Black's Law's Dictionary defines a franchise as follows, which is your all caps letter names. Franchise, a special privilege conferred by government on individual or corporation, in which does not belong to a citizen of a country, generally of common rights. In England, it is defined to be a royal privilege in the hands of a subject. A franchise, as used by Blackstone in defining warranto, had reference to a royal privilege or a branch of the king's prerogative subsiding in the hands of the subjects, must arise from the king's grant or be held by prescription. But today we understand a franchise to be some special privilege conferred by government on an individual, natural or artificial, which is not enjoyed by its citizens in general. In this country, a franchise is a privilege or immunity of a public nature which cannot be legally exercised without legislative grant. To be a corporation is a franchise. The various powers conferred on corporations are franchises. The execution of a policy of insurance by an insurance company, e.g., social insurance, socialist security, and the issuing banknote by an incorporated bank such as a Federal Reserve note are franchises. But it does not embrace the property acquired by the exercise of the franchisee, nor involve interest in land acquired by grantee. In a popular sense, the political rights of subjects and citizens are franchises, such as the right of suffrage, elective franchise, the right of suffrage, the right of a privilege of voting in public elections. Wow. Exclusive franchise, see exclusive privilege or franchise. General and special. The charter of a corporation is its general franchise, while a special franchise consists of any right granted by the public to use property for a public use but with private profits. Personal franchise, a franchise of corporate existence or one which authorizes the formation and existence of a corporation is sometimes called a personal franchise. as disguised from property franchise, which authorizes a corporation so formed to apply its property to some particular enterprise or exercise some special privilege in its employment, as for example, to construct and operate a railroad. All right, government instituted slavery using your all caps letter name, which is a corporation. Secondary franchises. The franchise of corporation existence being sometimes called the primary franchise of a corporation. Its secondary franchises are the special and peculiar rights, privileges, or grants which it may receive under its charter or from a municipal corporation, such as the right to use the public streets, exact polls, collect fares, etc. The franchise of a corporation are divided into one, corporate or general franchises, and two, special or secondary franchises. The former is the franchise to exist as a corporation, while the latter are certain rights and privileges conferred upon existing corporations. Special franchise. Notice the key phrase. In England, it is defined to be a royal privilege in the hands of subjects. This is a tact recognition that a loan of government property is occurring. They one use the word grant, which is defined as a revocable loan and not a permanent gift. Grants need not convey ownership in the thing granted. Public grants, a grant from the public, a grant of power, license, privilege, or property from the state or government to one or more individuals contained in or shown by a record, conveyance, patent, charter, etc. Black's Law Dictionary, 4th edition. 2. They use the words in the hands of a subject or subsisting in the hands of the subject, as if to imply that something, usually physical, is being loaned. 3. The recipient of the loan is referred to as a subject, and a subject is someone who owes allegiance and obedience to the lender. That's what all debts or loans do. The rich rules over the poor, and the borrower is servant, subject to the lender. Proverbs 22:7. The rich rules over the poor. Fourth, they describe a franchise as a special privilege conferred by government on individuals or a corporation and which does not belong to citizens of country generally of common right. This means that franchises are 1. Not law in a classical sense. Noble. Law must be not a special rule for a peculiar person or a peculiar case, but the general law, so that every citizen shall hold his life, liberty, property, and immunities under the protection of the general rules which govern society. A compact or agreement, but not law. Municipal law, the understood, is probably defined to be a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. It is also called a rule to distinguish it from a compact or agreement, for a compact is a promise proceeding from us. Law is a command directed to us. The language of a compact is, I will or will not do this. That of a law is, thou shalt or shalt not do it. It is true, there is an obligation which a compact carries with it, equal in point of conscience, so that of the law. But then the original of the obligation is different. In compacts, we ourselves determine and promise what shall be done before we are obliged to do it. In law, we are obliged to act without ourselves determining or promising anything at all. Upon these accounts, law is defined to be a rule. Readings on the History and System of Common Law, second edition. Special law that applies only to those who consent. Special law, one relating to particular persons or things, one made for individual cases or for particular places or districts, one operating upon a selected class rather than upon the public generally. A private law, a law is special when it is different from others of the same general kind or designed for a particular purpose, or limited in range or confined in a prescribed field of action or operations. A special law relates to either particular persons, places, or things, or to persons, places, or things which, though not particularized, are separated by any method of selection from the whole class to which the law might, but not such legislation, be applied. A special law applies only to an individual or a number of individuals out of a single class, similarly situated and affected, or to a special locality. Private law that does not apply to all citizens. Private law, that portion of the law which defines, regulates, enforces, and administers relationships among individuals, associations, and corporations, and used in contradistinction to public law. The term means all that part of the law which is administered between citizens and citizens, or which is concerned with the definition, regulation, and enforcement of rights in case where both the person in whom the right inheres and the person upon whom the obligation is incident are private individuals. See also private bill, special law, compare public law. Black's Laws Dictionary, 6th edition. 5. They refer to a franchise as a special franchise. Consists in any rights granted by the public to use property for a public use, but with private profits. Wow. An example of a franchise would be the commercial use of the public roadways for private personal gain. That franchise, in fact, is the foundation of all driver's licensing statutes. The following are contemporary synonyms for the word franchise. In earlier times, at the founding of this country, franchises were called patronage, public right, publici juris, privilege, benefit, entitlement, excise, taxable privilege, public office. Is it a franchise? A franchise is said to be a right reserved to the people by the Constitution as the elective franchise. Again, it is said to be a privilege conferred by grant from government and vested in one or more individual as a public office. Corporations or body politics are the most usual franchises known to our laws. In England, they are very numerous and are defined to be royal privileges in the hands of a subject. And information will lie in many cases growing out of these grants, especially where corporations are concerned, as by the Statute of 9 in Chapter 20, and in which the public have an interest. One strange R, the King versus Sir William Luther. It was held that an information of this kind did not lie in the case of a private rights where no franchise of the crown has been invaded. If this is so, if in England a privilege existing in a subject which the king alone could grant constitute it a franchise in this country under our institutions, a privilege or immunity of a public nature which could not be exercised without a legislative grant would also be a franchise. People versus Wrigley. 8. Congressionally created right. 9. Trade or a business. See 26 U.S. Code 7701 826. All government franchises are contracts between the grantor, which is the government, and the grantee, which is the private citizen. As a rule, franchises spring from contracts between the sovereign power and private citizen, made upon valuable consideration for purposes of individual advantages as well as public benefit, and thus a franchise partakes of a double nature and character. So far as it affects or concerns the public, it is publici juris, and is subject to governmental control. The legislator may prescribe the manner of granting it, to whom it may be granted, the conditions and terms upon which it may be held, and the duty of the grantee to the public in exercising it, and may also provide for its forfeiture upon the failure of the grantee to perform that duty. But when granted, it becomes the property of the grantee and is a private right subject only to the governmental control growing out of its other nature as publici juris. American Jurisprudence, 2nd edition, franchises. The term publici juris, as used upon, is defined as follows. Publici juris, Latin, a public right. The word public in this sense means pertaining to the people or affecting the community at large, that which concerns a multitude of people. And the word right, as used, means a well-founded claim, an interest, concern, advantage, benefit. This term, as applied to a thing or a right, means that it is open to or accessible by all persons. It designates things which are owned by the public, that is, the entire state or community, and not by any private person. When a thing is common property, so that anyone can make use of it who likes, it is said to be publici juris, as in the case of light, air, and public water. Public Laws Dictionary, 4th edition. Franchises are therefore an outgrowth of our absolute right to contract, and they require either implicit or explicit consent in order for the term of the franchise agreement to be enforced against you. They are public property. Based on the last definition, they always result in the conversion of your formerly private property to public property, a public use, a public purpose, and or public office in the government, which is a polite way of saying that all those who participate must do all the following in order to participate. 1. Donate their private property to the public in order to qualify for benefits. 2. Surrender their rights to exclusively own some or all of their formerly private property. 3. Transform from a sovereign to a subject and a serf. 4. Transform from a de jure citizen to nothing more than a fed employee or public office on official business. 5. Join a socialist collective called the public or a corporation called the state as a public officer. 6. Consent to transform a de jure government into a de facto private corporate monopoly that only doesn't protect private rights but systematically destroys them and make them illegal for all practical purposes. 7. Consent to allow your donations to the franchise to be illegally used to bribe other people to expand and populate the system and Ponzi scheme. Whew. Damn, they out here fucking shit up. Government franchise equal privilege equal public office. Another name for a franchise is a privilege. All privileges attached to offices. Privilege, a noun. Middle English from Anglo-French from Latin privilegium, law for or against a private person. from previous privates 12th century, a right or immunity granted as a peculiar benefit, advantage, or favor, prerogative, especially such as a right or immunity attached specifically to a position or an office. Okay, Merriam-Webster's College Dictionary, 11th edition. Based on the definition of a privilege above, all privileges and therefore franchises attached to offices in the government, if the privilege is granted by the government. An office in the government is called a public office. It is interesting to note that the entire income tax code is built upon the presumption that all taxpayers are in fact public offices in government. 26 U.S. Code Section 7701A26. The term trade or business includes the performance of the functions of a public office. The above is why we call the income tax as a franchise tax and an excise tax. All excise taxes are based upon the exercise of privileges. Damn, they out here wilding. Excise tax, a tax imposed on the performance of an act.